Thank you so much, and thank you for coming this morning. Mitch McAdam with me, as mentioned, Director of our Constitutional Branch at the Ministry of Justice. So today we're formally introducing the Saskatchewan First Act, the product of many months of intense legal and economic analysis, a lot of work. At its root, the bill asserts Saskatchewan's exclusive jurisdiction over natural resources, which we must protect. Our natural resources are one of the major reasons why Saskatchewan is weathering the economic recessionary storm experienced elsewhere. But economic success and strength don't just happen by accident. They happen when regulatory and royalty structures are strong, competitive, and transparent. They happen when you pound the pavement in Canada and around the world, telling Saskatchewan's amazing investment story. Economic success happens when you don't turn your back on workers in traditional sectors, when you build on the strengths of those traditional sectors and diversify and expand into new ones. Economic success happens because you create a pro-business, pro-investment climate. This bill is about ensuring and protecting that. The economic success that Saskatchewan has achieved has been despite federal policies that have done real economic harm and risk doing much more. This bill will create the framework to define, address, and quantify economic harm, because that harm is real and is being perpetrated on just one region. We're tired of the double standards and, frankly, of the contempt for ordinary working people and their livelihoods. When it comes to the quantification of economic harm, it's simply economically dishonest to suggest that carbon tax rebates offset the totality of that $111 billion harm. Businesses don't get rebates. Those who don't file taxes don't get rebates. The federal government is withholding hundreds of millions of dollars from Sask Power in carbon tax, which it could invest in renewables and power security right here in Saskatchewan. And don't forget, this past January, the Federal Parliamentary Budget Officer found that the carbon tax has left 60% of Canadian households financially burdened, as in worse off, including when the impact of the wider economy is added into the equation and indirect costs are passed on to businesses. That's no surprise. The report also reminded us that Saskatchewan producers will be paying $28 million a year in carbon tax for grain drying by 2030. Clearly, policies such as this have a root cause effect on affordability. Another example of economic harm, the federal fuel standard, carbon tax number 2, which came into force in June and will take effect next year. According to Saskatchewan, it will have an impact of $700 million a year on both gas consumption and diesel consumption. Just one set of regulations, not offset by anything, and a huge impact on retail, rail, the ag sector, the export sector, trucking, manufacturing, and of course, heating your home and fueling your car. Direct economic harm. In terms of the constitutionality and legality of this bill, we are amending Saskatchewan's Constitution by virtue of Section 45 of the Constitution Act 1982, which provides that a provincial legislature can unilaterally amend its constitution. By that means, we are asserting our exclusive constitutional jurisdiction, enumerating our core provincial powers, and referring questions for economic assessment to an independent economic tribunal. This is not merely symbolic. Amending our Constitution as Quebec did, as the Prime Minister said it was within the powers of provinces to do, and enumerating our core provincial powers, in other words, only those that relate specifically to Saskatchewan, we believe will have real, practical, and legal effect and weight in the future. And assessing economic harm, putting a dollar figure on it, will help identify evidence for potential future cases, including a reference to the Court of Appeal as one example. And it will help overcome what can be challenging legal thresholds to obtain, for example, an interlocutory injunction, one test of which is establishing irreparable harm. Far from this bill being unpatriotic, as some have suggested, I would counter, is it not patriotic to ask for a fair deal, to rely on the strict interpretation of the division of powers under the Constitution, and to ask that the federal government be an honorable partner with Saskatchewan? That, to me, defines being Canadian. We do not relish being here, but this is where we are. Quebecer Michel Kelly-Gagnon wrote recently about what Quebec has demanded constitutionally and what that signals to other provinces. He put it this way: sometimes a provincial government ends up having the powers it dares to take, not just the powers that are handed to it. Today in Saskatchewan, we choose to dare to assert what is ours under the Constitution. Thank you, and we're happy to take any questions.
You had mentioned that this will have legal effect. Can you maybe expand on what that means and how so?
Absolutely. So first of all, the amendment of a constitution isn't just symbolic, it's significant and happens very, very rarely, as we saw with the CPR case, which is the only other case of that in Saskatchewan. And so the amendment of Section 45 sends a signal also to the courts that we take this seriously enough to signal exclusive jurisdiction being part of that which is in the Constitution of Saskatchewan. In terms of the economic harm component, quantifying, we feel, economic harm of specific regulations, legislation, and so on, will form important evidentiary information for potential future cases. And I mentioned, for example, interlocutory injunctions, which have a very high legal threshold to pass, one of which is irreparable harm. So we feel that, for example, where you have the clean electricity regulations that are coming imminently, we hope not, but that's the apparent plan, where you have all fossil fuel generated power cut off by 2035, which Sask Power has said is literally impossible in this province, you have economic harm. And so we would look, for example, at defining, quantifying, assessing that economic harm in dollar figure terms and potentially using that as evidence in a future case against that passing, in the country. I think it's important, I'm so sorry, I'll just say that the exclusive jurisdiction part, of course, already exists, but we feel it's very important as part of the autonomy conversation to signal that as very, very important legally for us in the province, and we feel that defining those core powers of the province will have, as I say, practical and legal weight because they are defined in the Act.
And will you use, I guess, this Act to disregard federal environment policies in the future?
It's not about disregarding any laws, it's about following the law. And this is, after all, the Constitution, and 92A provides exclusive jurisdiction to the provinces over natural resources. This asserts and confirms that in our Constitution, And it's interesting, there is a lot of talk about federal paramountcy, for example. And we're seeing over the course of the last few years some discussion in legal circles about how federal paramountcy is increasingly being used as a veto. And where you have, and it's another constitutional term, interjurisdictional immunity, you have that for exclusive federal powers. You also have that for exclusive provincial powers. And we feel it's important to assert what our exclusive powers are under the Constitution. So it's not about ignoring anything, it's about asserting and quantifying what that means to the province of Saskatchewan when we are asserting and defining, redefining what exclusive jurisdiction is.
Just a question on the Sask Power issue. If this goes forward, does that prevent, does it allow Sask Power to keep burning coal, natural gas past 2035?
Well, we have a proposal into the federal government, as you know, on the output-based pricing system. So again, we have tried to work with the federal government in that regard. In terms of, if you're referring to the carbon tax dollars that are being held in ransom, if you like, by the federal government, that of course remains a concern to us because we feel that that is money that could be invested right here in Saskatchewan. In terms of coal, obviously those have been federal mandates that have been in place and been rolled out for some time. In terms of what this act would signal, it would look very, very strongly at going forward, what can we do? So for example, around natural gas generated power. In terms of 2035, the clean electricity regulations, which stipulate, as I said, that there will be no fossil fuel generated power by 2035. That's the equivalent of shutting down the city of Saskatoon, generated by the Queen Elizabeth Power Plant. So obviously economic harm, obviously social harm, obviously a massive concern to the province and the bottom line of the workings of this province. So we would look at, under this act, quantifying what that means and quantifying the effects of a policy such as that. In terms of coal, as I say, we've had communities which have been very, very affected in the southeast by the federal transition away from coal. We have looked at what we can do now going forward around SMRs, around natural gas generated power. In the meantime, we're very concerned that in the meantime, if that becomes subject to the 2035 federal clean fuel regulations, we're in a very difficult space in terms of that transition. So I think that if you look at an area around Coronach, for example, where you've had communities which have been mandated off coal, they would tell you that this glib idea that they will suddenly find green jobs has been just that, a glib idea. And they haven't been consulted with. And they do serve as a cautionary tale for transitioning off anything too quickly and the economic harm that comes about when you do.
It sounds like you conceded on coal and that you've accepted that it's going to be phased out.
Well, we have provincial mandates in place as well about renewables by 2035 and finding transition ways of generating power. We've been very open about that in terms of signaling the importance of natural gas to that conversation, of looking at solar, of looking at wind. We acknowledge the fact that the federal mandates have been in place now and rolled out over a number of years, and we've been very open about the fact that to fill that transition void, we have to look at such things such as natural gas. What's very concerning to us is that under the clean electricity regulations, for example, that fossil fuel generated power could be finished at 2035. That is a major concern to us. And if anything is economic harm and the possibility of economic harm, I don't know what else is if that isn't.
So just to ask this another way, do you feel that these changes will either allow the provincial government or be a legal basis for not abiding by some of the federal regulations coming down that you disagree with by saying that the federal government doesn't have jurisdiction in the province? So.
The exclusive jurisdiction under 92A has been in place for a very long time. And so we are merely asserting that that is in the Constitution, and that will help, and that quantifying the impact of infringement into that exclusive jurisdiction, which is what's happening with a lot of these regulations and legislation, will potentially help establish a legal basis for challenging. But keep in mind, this isn't about going against the law, it's about asserting what's in the constitutional law, and that's very important. So, for example, with the carbon tax decision, of course, and there's always interplay of interpretation between, and that's long been the case, of course, in the area of constitutional laws. It's been in the area of other areas of law. But you have differing interpretations, in this case, of which jurisdiction has exclusivity. And as we know, in the carbon tax decision, it was found that federal jurisdiction, if you like, trumped provincial jurisdiction. However, if you look at the Bill C-69 case coming out of Alberta, you have a court of appeal which found very much for the exclusive jurisdiction of the provinces. So it's not so much about not following Bill C-69 as challenging the federal power to put in place policies such as that, such as the clean electricity regulations, such as the clean fuel standard. These are direct infringements into provincial jurisdiction under the Constitution, and so we are asserting that by amending our own Constitution, which will have legal weight, and we are defining in the bill what constitutes our core powers, and that's another legal term, that provinces and the federal government have core powers. And we are also highlighting the idea of interjurisdictional immunity, which is a constitutional concept, which means there's federal exclusive jurisdiction and there's provincial exclusive jurisdiction. And it is exclusive under 92A. That word was carefully chosen. It's not up for debate.
I'm just trying to get a handle on practical reasons of why. So you feel this change will help you with a legal basis in any future legal challenge if you have to go to court about it?
We do, and we feel that the economic tribunal part of this is very important. It's why it's there in the bill, that the economic tribunal, which will be independent, will assess the dollar figure impact of some of these regulations, some legislation, and advise publicly what that is. And we know, for example, that the Ministry of Finance has recently found the $111 billion impact. That is the Ministry of Finance. Of course, that's very weighty. I'm assuming that going forward, we will work with them, we will work with the independent tribunal to put dollar figures on policies. And that will then be something we can file as evidence in a court case, use in an interlocutory injunction, which, as I say, one of the legal tests is irreparable harm. And in some of these cases, if you're looking at $700 million a year for the federal fuel standard, or you're looking at clean electricity regulations which say no fossil fuel generated power by 2035, what that means for the province of Saskatchewan, which regularly goes to -40, there's economic harm. There's more than economic harm to that. So we feel that it's important to define these policies through the prism of economic harm. That's really what this is about, is protecting our economy and our way of life while we work to solutions around, for example, small modular reactors and the rest. All our mandates and missions provincially in terms of cutting emissions, that's all still on the books, of course. The point is, though, that where there is direct infringement in our exclusive jurisdiction, we do feel it's important to formally now draw the line.
Once the Saskatchewan Act is amended, will you take it to the House of Commons and ask them to adopt it in their constitution, or the Canadian Constitution?
It's not about going to the House of Commons to ask for that. We are simply using the same amendment section in both the Constitution Act and the Saskatchewan Constitution.
Well, why not adopt it into the Constitution like we saw with the CPR taxation
different formula, different amending formula. That was bilateral because of the deal between CPR and Canada. This is something which we can unilaterally under Section 45 amend, and we're simply doing, for example, what Quebec did, and which has been signaled as something provinces can do. It's explicit in Section 45, but this was the discussion a few years ago about asymmetrical federalism. The Prime Minister acknowledged that this is something that provinces can do, and we believe legally that that is a very sound way of approaching this.
Will this automatically trigger the federal government to challenge you legally, for Mitch or the minister?
We're not sure what the federal government will do. We feel that this is legally sound, certainly constitutionally sound. We feel that establishing economic parameters around harm will help us define and quantify what we are looking at in terms of asserting exclusive jurisdiction. I can't speak for the federal government, but we have done an immense amount of work in terms of the legal and constitutional framework around this.
And how did the carbon tax case maybe frame some of this? Was that something that we learned from on how we could argue what you're arguing today? Is that something that was useful?
Well, I think in terms of the prism of economic harm, and as I mentioned earlier, I mean, the parliamentary budget officer found that 60% of households in Canada are worse off as a result of the carbon tax, that there's enormous economic, indirect and direct effect from the carbon tax. It is a root cause affecting affordability, one of many. I think that if we look at the effect on producers, with grain drying, if we look at the effect of transport, retail, rail, manufacturing, I mean, these are things that rebates don't cover off. There is economic harm. So I think in terms of that, I think in terms of the federal fuel standard, I think in terms of the clean electricity regulations, I think it's important to look at economic impact, but not only economic impact, exclusive jurisdiction under Section 92A, that is the provinces of Saskatchewan's under the Constitution, under the law. And it's important, I think, to take the step in the Constitution of the province to assert that.
And, sorry, I just want to you mentioned that the Ministry of Finance's $111 billion was weighty, but I think everyone in this room found economists fairly easily on below that study. Who's going to be on this economic tribunal? How is it going to be?
Well, I guess I would reject the premise. The $111 billion figure, I mean, let's not forget, was arrived at by the Ministry of Finance. If we don't take into, yes, I know, I know, but if we don't take into account the Ministry of Finance's ability to assess these things, then, you know, we have to think twice about a lot of things. I absolutely do. The major argument against those numbers was on the basis of carbon tax rebates. And as I've said, carbon tax rebates, you cannot suggest that carbon tax rebates offset $111 billion in economic harm. Businesses don't pay it. Sask Power is owed hundreds of millions of dollars under it. People who don't file taxes don't pay it. But more to the point, it's the indirect and direct impact of these things. And as I said, federal fuel standard, $700 million a year. One set of regulations, no offsets. Clean electricity regulations, one set of regulations, huge impact. So I think I disagree with the rejection of those numbers based on carbon tax rebates, particularly when, as I've said, parliamentary budget officer found very, very differently. So I would challenge that. And I would ask economists and other critics to show us where, and the numbers have been tabulated, they have been sent to the federal government on numerous occasions, on something such as the clean fuel standard. They have been calculated and they have not been rejected.
Do you think if you worked with the federal government in establishing a provincial carbon plan or a carbon tax, that you wouldn't find yourself in this situation today?
Well, as I say, on the output-based pricing system, we have proposal in front of the federal government. It's up to them to come back and let us know what they intend to do with it and with us. I would say on the issue of working with the federal government, I think that's another thing that's important. It's important to point out that, of course, we do. I've had good relationships with ministerial colleagues in energy and resources, for example. Minister O'Regan, I had a very congenial relationship. We didn't always agree, but we remain in contact. Minister Wilkinson mentioned that he had a good relationship with me when he was in town a few months ago. We don't always agree, but I think that is also lost in the narrative. There are efforts all the time. And I would point, for example, to methane, which is also part of the white paper, which you'll have read, and the impacts of the methane regulations. The province of Saskatchewan has equivalency on methane. It's not known about much, but it's there. And we worked very, very long and hard with the federal government to reach equivalency on methane. Our methane dropped by 50% last year. We were congratulated publicly by Minister Guilbeault, and then they went and changed the thresholds, and I believe have changed them again. So I think part of the frustration is that we get to a point where we work together and we, in the case of methane, for example, even have their approval, their congratulations, and then the rules are changed again. And one of the biggest problems we have in the province, and when I talk about an honorable deal or a fair deal or an honorable partnership, you cannot impose things on provinces whose exclusive jurisdiction these areas are, and not show them the data you're using to impose these things on them. And that happens all the time. It happens in methane. That's not an honorable partnership. And we would like an honorable partnership. This isn't about Fed bashing for kicks. This is about quantifying, assessing, and defining economic harm. It's about our place in this federation and our responsibility to the people of Saskatchewan to foster economic growth.
What do you say to critics, though, if we're going to say, you define your costs, this is how much it's costing us, and then we're reasserting what we already have in the Constitution? I don't think that really changes anything. It doesn't really get you anything. It's not moving anything.
Well, first of all, on reasserting our exclusive jurisdiction under the Constitution, legally, there is a weight to that. And Mitch, I'm sure, could go on. He has with me for many hours about the impact of that before the courts. It's very unusual. It's bold, rare that provinces amend their constitutions. In this case, we are amending it to state and remind and confirm our exclusive jurisdiction. That is not merely symbolic. It has legal weight. We then enumerate our core provincial powers in the bill. That also has legal weight. It has practical weight and for us in terms of understanding the economic harm as well, but it has legal weight. And when we have a dollar figure, and keep in mind at this tribunal, we will be asking for the federal numbers too. We will be submitting our numbers. We want it to be fair, transparent, independent, but we want to try to arrive at a real assessment of what some of these programs cost. And of course, we'll be asking the federal government on methane, on the clean electricity regulations, on the federal fuel standard. They've often admitted the cost is significant. They haven't not admitted that. So let's at least look at it from the basis of dollars and cents. Let's look at it from the basis of what exclusive jurisdiction under 92A means. If there's federal exclusive jurisdiction, there's also provincial. That's part of being part of this wonderful, crazy patchwork that we call Canada. And it is not unpatriotic to point that out. We want to be honorable partners, but that means we're both clear on our exclusive jurisdictions.
This question is for Mitch. I guess what additional powers would we get by implementing such an act and amending our Constitution?
Thanks for the question. And I think it's important to point out that this is a unilateral amendment to the province's constitution that's made under Section 45 of the Constitution Act 1982. So there's nothing in the amendments that say that the province can disregard federal laws or that federal laws will no longer apply in Saskatchewan. what the law does is it recognizes that that's the role of the courts, and the courts are the ultimate arbiters of where that dividing line is between federal and provincial jurisdiction. But where we see this bill as assisting the province's agenda going forward is in two different ways. First, as the minister has pointed out, the amendment to the province's constitution will assert the province's autonomy and sovereignty with respect to those things that the province has exclusive jurisdiction already under the constitution over, things like non-renewable natural resources and the generation of electrical power. So that's important because it's, as the minister pointed out, it's not just symbolic. That's something that the courts can look to and can be an interpretive aid when the courts are called upon to decide where that boundary line is. The second thing that the bill does that we think is important and really has practical significance is the creation of the tribunal that will look at the economic harm and will determine what the impact of a federal regulation or initiative actually is in Saskatchewan. And then, again, as the minister pointed out, once we have that information, then it can inform future decisions, whether that's a reference case to the Court of Appeal, whether that's seeking an injunction or something else. But it will give us those tools that we need to take that case forward to the courts.
And then a follow-up for you. Do you believe that the carbon tax set a precedent for other federal environment policies?
Well, I think one of the earlier questions was whether we learned any lessons from the carbon tax case, and certainly we always learn lessons from every case that we've been involved in. The one thing that I would say about the carbon tax case is it wasn't the usual type of debate between federal and provincial jurisdiction. What the federal government's lawyers did in that case is they relied on the Peace, Order, and Good Government Clause in the Constitution and the National Concern Branch, which, as the minister described, is basically a trump card over provincial jurisdiction. It's a power that they can rely on to say that under the usual division of powers, this is a provincial matter, but we're asserting the Peace, Order, and Good Government Clause, and we're going to take that power over. And ultimately, the Supreme Court agreed with their argument in that case. So that's very different than the usual sort of jurisdictional debates that we get involved in, the usual sort of constitutional cases that we're involved in. But we think that this bill will help in those other cases.
This is the province getting ready for the flush, basically.
No, not necessarily. This is about the province processing the impact of these regulations, legislation, programs. I mean, we've known about these for a long period of time. For, as I say, example, the electricity, clean electricity regulations that we hope will not be a reality, but if they are, will phase out fossil fuel generated power. We don't have enough hydro to see us through that. We don't have enough ability to transition that quickly. We are trying, and those efforts have been well documented. But we will look at those electricity regulations as one set of regulations, which we may pursue in terms of assessing the economic harm, the economic dollar figure behind bringing those in. You can imagine what that would mean to the province of Saskatchewan economically. So it's not getting ready for a fight necessarily, it's about following the process. We now have asserted our exclusive jurisdiction, that clearly falls under it. We will then take something like this forward to the Economic Tribunal, we will do the analysis, and we will then decide what we would do in a case such as that. Whether it would be applying for an interlocutory injunction, whether it would be a reference to the Court of Appeal. But we feel that we're trying to do everything we can to protect ourselves by doing this. I don't expect a great deal more than a normal tribunal would. We will have a chair, we'll have a vice chair, we will have specialists, I think, is an important component. So a flexible ability of the tribunal to call experts in a given area. People who talk about methane for a living are perhaps different than those who talk about fossil fuel generated power in the gas sector, for example, or the federal fuel standard. It will be specific to those sectors affected, and in terms of specialists and the discretion of the chair to call specialists whom he or she feels will be able to best assess economic harm. So really a very similar structure to other tribunals that we have on the books here in Saskatchewan. Not cost-wise at this time. One of the things that we will be looking at now as we move this forward will be the establishment of the tribunal, and certainly we'll try to keep it as conservative cost-wise as possible. Probably based on cases. I would say that would make the most sense, and I think that's how we see it, that for example, if we're assessing the federal fuel standard or the clean electricity regulations, it will be a matter of hearing those and having a certain period of time, I believe it's 90 days, to come back with an assessment. If more time is needed, more time is needed. It will be intensive in terms of parsing those dollar figures, of course, and to get us to this point has taken a lot of work as a government to do this right, legally and economically, and certainly we would hope and expect that the tribunal would do the same, to take the time to assess economically. Absolutely publicly available in terms of final reports. We haven't got to the point of hearings yet and how that will be managed. But really the idea of the tribunal is that it be independent, that it be transparent, and that it be accountable. This is just about facts, finding facts. And I think where dollar figures are involved, I'm not sure that there's enough awareness out there about some of the real dollar economic impacts to some of these programs. This would be about trying to fill out that picture for people and for us. It'll be by OC, so Order in Council. Well, the Impact Assessment Act, we are intervening, as you say, and that's AKA Bill C-69. That just carries on. And obviously we have an interest in that case because of the very, very strong role that exclusive jurisdiction played in that case. So we found that hopeful when the Court of Appeal clearly defined that concern, taking a wrecking ball as the court found to exclusive jurisdiction of the provinces. That intervention goes on separately from this. This is more about now addressing the impact of federal policies and regulations on the province. I suppose in terms of something such as Bill C-69 or pipelines, as we've often talked about, the economic harm, direct and indirect, is significant. So will that inform things? Potentially. But I think that intervention-wise, that will just be its own separate process.
And then
Well, primarily, if you look at, for example, the energy sector, of course, we are very present in the energy sector, as is Alberta. And, yes, to a certain extent, Newfoundland and so on. But where we see impacts, massive impacts economically on sectors, it's predominantly here in the West that we see them. So caps on oil production, the methane regulations, federal fuel standards, because it's about diesel producing and diesel consumption. It's about gas production and gas consumption. And so where we have strengths there in the sector, they are predominantly impacted. One of the other arguments that I've heard in the last few weeks is, well, things are going so well, why would you possibly be interested in economic harm when the economy is booming? And I think that with respect is disingenuous, because let's not forget that 2 years ago, oil was in negative production. And we've certainly seen ups and downs with uranium and potash. And we know those, we've all lived through them. And so I think this idea that somehow now that things are good, why would you be interested in ever defining anything when things are challenging, or even when things are booming, is unfortunate, because it's really about being there for sectors and the economy in challenging times and in good times. And really the reason that the world is paying attention to Saskatchewan in helium, for example, or energy in the way we produce it, is because of all the work that goes into producing a business-friendly, investment-friendly climate. Despite all the headwinds, Impact Assessment Act is one, lack of pipelines is another. And so we have, despite these policies, thrived. And as I say, the world is paying attention to Saskatchewan for that reason. We want to protect that, because really the broader economy is about affordability. And it's about hedging our bets to the next more challenging time, which we have just been through. Mitch, certainly you can weigh in, but based on the Constitution Act 1982 and that which was fought for in terms of exclusive jurisdiction of the provinces over these areas, yes, we do. Well, any other prescribed matter where there is infringement on exclusive jurisdiction of the province. I think of, there has been some talk around the economic impact of federal policies on immigration, for example. There are issues around caribou management would be another. It's very specific, but very important. And so there are areas where the federal government has imposed things, again, on provinces, which affect directly and come up against that exclusive jurisdiction under 92A. And it's been sometimes under the guise of environmental regulation, but it directly impacts the exclusive jurisdiction under the Constitution. So it's really, G is a bit of a catch-all for that which may be TBD, but still is very much in the ambit of exclusive jurisdiction consistently with the rest. It doesn't go off into some other area. It would be held within that 92A context. Not doing enough, but doing. And for example, I referenced methane, for example. I mean, we have had very significant success in bringing down methane in the province, independent of federal regulation. 50% just announced last December. That's significant. So the reason that we kept it at economic harm was to keep it at that, economic harm. The efforts that the province is making and taking around lowering emissions and guidelines around dates for doing so remain in place. This isn't about undermining any of that. It's really, though, about, again, within the context of that which is provincial and imposed on that which is provincial by the federal, what are some of the dollar impacts of that? And we feel that that keeps it quite narrow and focused, because the economic harm is something we can quantify And as I say, for example, in terms of the federal fuel standard, there are all kinds of aspects to that. And for example, in the interim, we'll have to import a lot of ethanol from the US while we get our infrastructure up and running in that area, because we just don't have the infrastructure online yet. We're getting there, and we'll get there. In the meantime, however, with the federal fuel standard coming into play next year, $700 million in impact every year, one set of regulations, no rebates. So we feel that it's important to look at these things in the context of exclusive jurisdiction, but also when there is an infringement on exclusive jurisdiction, dollar harm.
En français, quelques mots en fait sur le First Act, ça empêcherait concrètement Ottawa d'imposer la Constitution.
Je ne peux pas entendre très bien. Est-ce qu'on pourrait faire le français après? Est-ce que ça irait? Oui, OK. Absolutely a fundamental one. And I think of, for example, the fact that the president of the National Coalition of Chiefs addressed a federal committee within this last year, and the federal committee was looking at oil and gas caps. And he said the biggest problem was the way these caps would impact First Nations economies and their ability to finally share in Canada's resource economy and get people out of poverty. I think that the fact is that there is no diminishing or detracting of First Nations treaty rights according to what we are proposing in any way. This is simply to unlock the economic potential of the province for the benefit of everyone, to protect it. And Section 92A has been on the books for an awfully long time. As I say, this simply asserts that and our ability as a province to grow. And when we look at the incredible role that First Nations have played in unlocking that potential in this province. Forestry, for example, employs more First Nations in Saskatchewan than any other province. We've seen enormous participation in the uranium sector. Cameco, traditionally the biggest employer of First Nations in the country. See the mines coming online in the north, Seabee, Foran, first carbon neutral copper mine. These are good news for our Indigenous partners, and they say as much, they tell us as much. So this is about working together, about economic potential and unlocking it in the province and protecting it. There is no delineation between one set of rights and another. They're absolutely complementary and remain so under the Constitution, under Section 35. We have said, and we continue to say, that the resources of this province are for everyone, and that it is about economic potential for everyone. And there are many First Nations partners in the province who say the same thing and want the resource potential of this province fostered, encouraged, and protected so that they can participate in the potentials for their communities around resource development. And so that is something that is for everyone in Saskatchewan.
Are there any concerns that this will create an us versus them mentality that
Well, I hope not. And I wouldn't want to say that we're at a point where we sometimes feel that way, but I will say it. We would like to be honorable partners. We would like to be honorable partners, and we hope that that which has been extended, for example, to Quebec and signaled in terms of provinces' ability to amend their own constitutions is something that we are fully within our legal ability to do and our provincial ability to do, and we hope that merely by signaling this and signaling that we want to analyze the economic harm, that raises awareness about two things: exclusive jurisdiction and economic harm. And we continue to work with the federal government when we can, and I've signaled some of the areas where we have and do. And this isn't about relishing this or politicizing it. It's about defining something that is of serious consequence to us as a province. That's our job. We have to do that.
Is there any argument that could be made that climate change presents a challenge that
Well, I guess I would say a few things. First of all, I would say that all the efforts that we are making to address climate change are ongoing. And we've made enormous strides. And some of you have heard me on this before, but I do maintain that it's important to get out the message about the sustainability of our resources in this province. And I think that that's something that we, as part of the climate conversation, have to do. That when companies and countries invest in Saskatchewan or import from Saskatchewan, they are importing potash that's 50% less GHG producing than in Russia or Kazakhstan, or that oil and gas that's extracted and produced in Saskatchewan and in Western Canada. If everyone in the world produced and extracted the way we do, energy-produced GHGs would instantly fall by 25%. So it's not an either-or on sustainability or economy. They do work together. But as we've seen with the developments in recent months, they absolutely must work together, or we have serious issues, and other jurisdictions are facing these. We have to be very, very sensible about impacts of, for example, too rapid transition, 2035, no fossil fuel generated power. And we have to look very hard at the effects of policies. I mean, for example, a lot of talk now about LNG. Wouldn't it have been nice to be able to export to Germany a Canada-made LNG from Saguenay, for example? And Saguenay was shut down by Bill C-69, but also by the province of Quebec, and we respect those decisions. But the point is that now that the country is looking to us, as we saw Germany looking to Canada for clean energy, we could provide it. And so it's about now defining what it means to harm one economic region when the world is casting about for clean options, as we all move to, call it transition, call it what you will. But we play a role in that as Canada, and certainly as Saskatchewan, and we can't dismiss that. So everything works together.
This is something.
Well, as I said, we've been doing the work for many months. The legal analysis, the economic analysis. This is our bill. Alberta does not have a bill. And we're very proud of how we have got there and the legal constitutional soundness of the bill and the approach with the Economic Tribunal, which is unique to us. So this is ours and ours alone. They can challenge it, of course. And Mitch, if you want to maybe speak very briefly to the amendment of the two acts and how we feel those interlock into each other and the soundness of that, our ability to do that.
Yeah, thank you, Minister. I mean, of course, the federal government could challenge the bill in court, but we feel very confident that the province has the jurisdiction under Section 45 of the Constitution Act 1982 to unilaterally amend its own constitution. So you'll see in the bill that there are two different ways that we're doing that. One is by amending the Constitution Act 1867, And there's a part of that act that deals with provincial constitutions. It's the part that Quebec relied on to make their amendment a few months ago. So we would be making an amendment to that part of the act. And also, the bill deals with an amendment to the Saskatchewan Act, which we view as part of the constitution of the province as well. So we think we're on solid ground with respect to either and both of those amendments, based on the fact that these amendments don't purport to change the division of powers between the federal and provincial government. That's still something that's up to the courts to determine, but this is something that only deals with the provincial constitution and, as the minister has set out, is asserting the province's exclusive jurisdiction with respect to certain matters like natural resources, and then setting up the tribunal to determine economic harm. So we feel we're on solid constitutional footing with respect to both amendments.
Fine, Ms. McAdam will end there. If you have any questions, feel free to send them in.
Ce n'est pas seulement le taxe carbone, ce sont les régulations, la législation qui ont un impact économique sur la province. Alors, il y a vraiment deux parties. Il y a l'assertion de l'exclusivité juridictionnelle sous 92A. Et on veut vraiment confirmer l'importance de notre juridiction exclusive sous la Constitution. Et on pense que, en faisant cela, ça signale quelque chose d'important légalement, mais aussi économiquement, parce que une partie de la loi sera catégorisée et listée ceux qui sont notre juridiction et les aires de notre juridiction. Alors, vraiment, une analyse économique sera partie, en fait, des cas dans le futur où nous pourrions peut-être faire des submissions légaux au sujet de cette juridiction exceptionnelle ou exclusive.
Justement, comment est-ce que le First Act va être bénéfique pour la Sask Power?
Pardon?
Comment est-ce que le First Act va être bénéfique pour la Sask Power?
Ce n'est pas seulement bénéficiel ou ce n'est pas vraiment le but. Le but est vraiment d'exprimer et de définir ce qui sont nos pouvoirs exclusifs sous la Constitution. Et alors, ce qui a à faire avec Sask Power, par exemple, serait le fait qu'il paye le taxe et on n'a pas reçu le rebat qui est des millions de dollars par le gouvernement fédéral en attendant ce qu'ils vont faire avec cette rebat pour Sask Power. Et notre argument est que le fait de prendre cet argent et de ne pas le resoumettre est un problème économique pour nous. Mais plus généralement, le taxe de carbone, on analyserait en futur peut-être l'effet économique de ce taxe, mais aussi le fait que ce taxe est vraiment que ce taxe entre dans notre ère ou sujet d'exclusivité sous la Constitution. Alors, ce n'est pas à faire seulement avec SaskPower, c'est vraiment une analyse économique de législation et de régulation fédérale qui ont un impact sur la province.
Est-ce que vous n'avez pas peur que le First Act, ça fasse des représailles avec Ottawa?
On dirait que les problèmes avec Ottawa existent déjà. Ce n'est pas que nous voulions pas des solutions, ce n'est pas que nous voulions pas travailler avec Ottawa dans les cas où on peut, et qu'on ne le fait pas, on le fait. Dans l'ère de méthane, par exemple, et de réduction, on a l'équivalence fédérale avec le gouvernement fédéral, alors on travaille ensemble. Le problème est que l'exclusion juridique ne peut pas être seulement pour un gouvernement, dans ce cas fédéral. Ça existe sous la Constitution pour les provinces et pour le gouvernement fédéral. Alors pour nous, c'est vraiment important de confirmer que ça c'est la loi sous la Constitution. Ce n'est pas quelque chose qu'on ne veut pas argumenter, on veut asserter. Ok, merci. Alors nous allons traduire. Ok, merci. Thank you.